So now we will jump in right to our next panel. And my colleague Elena will be moderating the panel once again. And her joining will be Alexander Filip, Jade Nestor, and Dr. Aileen Pasquariello. But Elena will introduce the panelists to you once again. The discussion will dive around the topic of international or global data flows. But Elena, the stage is yours.
Thank you very much, Isabel. So let's move on with one of the most debated issues in data protection, global data transfers, and the regulatory evolution, as well as the challenges business face. I am delighted to be joined today by three experts on the topic, representing both business and supervisory authority perspectives. Mr. Alexander Filip, Executive Director and Head of Department G for Fundamental Issues, European Cooperation and International Data Transfers of the Bavarian State Office for Data Protection, Ms. Jade Nestor, Director of Data Public Policy for Europe at TikTok, and Dr. Aileen Pasquariello, Data Protection Officer at L'Oréal DACH, L'Oréal Germany. Thank you very much for joining us today and taking the time to be with us. I would like to start with a very timely development. Last week, the General Court rejected the annulment of the EU-US data privacy framework, confirming that the United States provide an adequate level of protection for personal data transferred from the European Union. This is particularly significant, we can say, since the previous two frameworks were invalidated in the Schrems I and II rulings. And this decision will influence future decisions and international data transfers. I have an opening question to all of you in this context. Against this backdrop, what impact do you think this ruling will have on the stability of transatlantic data transfers? And what will it mean for businesses and regulators going forward? Let's start with you, Mr. Filip.
Yeah, thank you. So thank you for the introduction, and thank you for making the link to the judgment which we saw some days ago, and I think which everyone in the community involved in data transfers has waited for. So from the regulator's perspective, this judgment is, of course, of importance. We have been waiting for that. And we realize that this judgment is will be able to provide some certainty to the stakeholders, to enterprises and other stakeholders exporting personal data outside of the EU. However, on the regulator side, we need to, at the same time, maybe to pour some water into the wine when communicating to the stakeholders as regards the consequences of this ruling, and I just want to highlight from the outset the issues which we will highlight in our communication when asked and when speaking to stakeholders. So first of all, the judgment is, of course, a judgment of the European Court in the first instance. So we will have to see whether the case will be brought to the European Court of Justice. It's still possible, so that's the first issue. Even if it will not be brought to the European Court of Justice, we need to emphasize that the court has looked at the legal situation in the US at the time of the Commission implementing decision, or of the Commission decision on adequacy for the DPF, for the US DPF. So developments in the United States legal framework and practice, which took place after the commission decision, so over the last 2 years more or less, have not played a role in the judgment. So that's the second issue, and we know that everybody is closely watching what's happening in the US in terms of possible changes of the legal framework. So these last 2 years have not been taken into account. So that's the second point. So that's the second issue which needs to be emphasized. So as regards to judgment, it provides some certainty for stakeholders, but only to a limited extent for the reasons outlined before. And generally, the regulator's perspective in data transfers is that, aside from this judgment, we will probably still have a very challenging situation as regards data transfers to third countries over the next years, as we have seen in the last years, because everybody is aware that the European Court of Justice highlighted that it is always the duty of the data exporter to provide legal certainty, to carry out an analysis of the legal situation in a third country. And we know that that's a challenge. So the regulators are trying to, and that was your question, are trying to provide some help, to provide guidance in order to make all these instruments for data transfers somehow workable and feasible. However, no matter what transfer instrument you will use, it's always the so-called transfer impact assessment, which will have to play the more or less the decisive role, and that's a burden which the European Court of Justice has put on the data exporters. The data protection authorities have provided guidance as regards how to carry out a transfer impact assessment some years ago in the so-called recommendations on supplementary measures. However, it needs to be stressed that it is a challenge because small and medium enterprises, and that's what the Court of Justice requires them to do, will have to check the legal situation and the practice in the third country. We provide guidance in order to help them do that, but it's an exercise which they have to do. So that's probably nothing the data protection authorities will involve in themselves. So providing a legal analysis for specific third countries, it's an exercise which small and medium enterprises will probably have a hard time to do. It's advisable for them to look at what data protection authorities say, but at the same time, the assessment needs to be done by them, probably in connection with the data importer, with law firms, with advisors, and so on. So no matter what guidance the authorities will provide, it's an exercise they will have to do, and that's a challenge that still remains. So maybe as regards what we have done as authorities in the last years to provide help for data transfers, we have been working on guidance for BCR for controllers, which is an important transfer instrument. We are in the course of finishing the work for the recommendations for BCR for processors. I'm one of the rapporteurs on that file, so we hope to finish that work over the next month, maybe by the end of the year. So BCR for controllers and processors are an important tool. We provide guidance for that. We are working on guidance, and we have already provided some guidance on certification as a tool for data transfers to third countries, but that isn't yet tested in practice to a high degree. So the guidance is there. It's a very more general guidance. Maybe when the applications will start in practice, we will provide additional guidance on that, but it's not sure yet. It remains to be seen. So BCR, there is guidance. Certification as a tool for transfer, there is guidance. The transfer impact assessment, there is guidance. And there's also guidance for codes of conduct as a transfer tool. So I think that's what we can do from our side.
Thank you very much, and thank you very much that you also pointed out the topic of the transfer impact assessment. It was something that I also wanted to mention. And over to you now, Ms. Nestor. I would like to ask you your evaluation about the ruling, the current ruling of the court, and the difficulties you actually face as a global platform dealing with different transfer regimes.
Yes, thank you. I think the ruling was helpful to confirm, of course, that it's not necessary for a third country to ensure that they have legal protections that are absolutely identical to those in the EU. So that was confirmed. in this decision. And I also thought it was interesting that Letombe argued that the Commission had specifically infringed on Article 32 of the GDPR with regards to security practices, basically saying that in the EU, there is this requirement for adequate security measures, and even though what's in the data protection framework is not identical in terms of security measures, that basically the effect was essentially the same. So you have to make sure, again, that there's this equivalence, but the language does not have to be the same. And I thought that looking at the security measures part was interesting because the US does tend to have a very robust cybersecurity culture and commercial practice. So I thought that was an interesting one where it was the words that were the issue, and the court basically said that the effect is what you're looking at, essentially. We also saw this with automated decision making, that they were looking at the sectoral system in the US and saying, again, there is a system that has some similarities with the EU. It doesn't have to be exactly the same. So I thought that that was an interesting piece to confirm. But of course, there is this question of whether we will see an appeal, whether there will be more challenges to the data protection framework. I don't think that we're through with this. We've seen 10 years of decisions. We've been waiting to exhale, as people say, for a long time, and I don't think that that will change. I think we will still see some tumultuous decisions in the future. So at least as privacy professionals, this keeps all of us engaged and gives us something to talk about. But for companies, it does create a great deal of regulatory uncertainty, which brings me to your second point about what the challenges are for businesses. For businesses, regulatory certainty is ideal. You seek to comply with the law and follow guidance so that you can meet regulatory expectations. And regulatory certainty also helps you invest in compliance solutions and helps you argue for the investments in those compliance solutions. And if you're seeking to comply with European law, if you're a company, any organization, you're already trying to comply with GDPR requirements around transfers, and that can be quite costly, as we just mentioned. This was also reinforced in the second report on the application of the GDPR. The GDPR expert group that was reviewing the GDPR, the multi-stakeholder expert group, stressed that the obligation, for example, to carry out transfer impact assessments was, in their words, burdensome, costly, and time-consuming. And in addition to the transfer impact assessments, companies are also implementing safeguards, which in, again, that GDPR experts group, they noted that that can be complex and costly as well, particularly when you're putting measures in like encryption. And in TikTok's case, we've put in a security program called Project Clover, and we've been safeguarding data this way, and it represents a 12 billion euro investment. And this includes data sovereignty with data centers in Ireland and Norway, and another we just announced in Finland, that's a €1 billion investment, and also large-scale deployment of privacy-enhancing technologies, including differential privacy, which is a state-of-the-art type of privacy, and third-party oversight. So we have those three different components. Now, this represents our investment, and you can see how the cost adds up. But if you're a small company and you're operating in multiple jurisdictions, it's really going to add up for you proportionally. And I think that the operational reality is that you would have to figure out how are you going to meet those regulatory expectations. And it does seem like the bar keeps moving, that in addition to the uncertainty with the US, that expectations around risk and just expectations around TIAs keep moving. And I always think of something like a small pharmaceutical company, or if you wanted to build a health app with a small niche audience, I think it would be really hard to deal with this transfers question while also applying safeguards to minimize risk to the level that an EU regulator wants, which is extremely high. So I think that could be very disincentivizing for those SMBs, which I think is an issue we've all recognized that can be a challenging issue. But there is this, I think, disincentivization that would happen if you are a small company, particularly if you're trying to do something novel, something interesting, and you don't really know where to start with this process.
Thank you very much. We would also like to listen to your perspective, not as a small company, but as a multinational company, Dr. Pasquariello. Your evaluation for the ruling, but also which strategies work for you the best to stay compliant while keeping process efficient?
Yeah, so as we all mentioned, it was kind of a breathing out at the time the ruling came, but it only provides interim stability. I mean, we know that adequacy decisions are crucial for operational ease and efficiency, and it's a lot of burden to keep SECs in place and BCRs in place. So adequacy decisions are really the go-for solution from a corporate perspective. So we remain observant and see what happens. So that basically brings me to the second point. What's our strategy? We need to find a way to stay resilient and flexible and efficient all at the same time in a big company. And so the first, and to be honest, I think every company tries to do the same. So the first thing is to get visibility over your data flows, of course. You need to map where data is going to remain flexible in case we have regulatory changes. So basically with one click, I want to see in which jurisdiction we have data to be able to identify vendors and see how we can adapt the legal frame in which we transfer data. So the second pillar then is to have the SECs on standby. So either be quick with your purchasing team to exchange the contractual or to touch the contractual basis to get it to SECs, or even to proactively conclude SECs as a fallback plan in case an adequacy decision falls. And similarly with the TIAs, we have TIAs in place for the key jurisdictions that are leveraged within the EU for the different entities. So we are sharing our insights on transfer impact assessments and then have to fine-tune them to the individual case. But this is also one way to be more efficient. Fourthly, we always have to review the renewal of certifications, of course. So even though we have an adequacy decision with the US, we need to check whether our vendors are actually holding up their certification. It's a regular review process, and we're also monitoring the adequacy decisions. And last but not least, wherever feasible, at least I advise to resort to EU vendors, the most resilient solution. But obviously, that's that doesn't always work. So, and it's good that it doesn't work. I mean, I don't know. I don't think we want to build up walls around Europe. So that's why we need to remain flexible and work with other countries. Those are basically the standard measures.
Yeah, thank you very much. And now that you pointed it out, we have also a question, and is for you, Mr. Filip. Could you please confirm that transfer impact assessments are only required if third country transfers are done on the basis of transfer instruments like SEC or binding corporate rules, but not if transfers are done based on adequate following from the EU-US data privacy framework? You can also see the question, I think.
Yes. The answer is yes.
Only yes. Okay. Thank you very much. Then we will go on with the other questions. And I would like to go back to you, Dr. Pasquariello, and ask you which upcoming regulatory changes worry you the most as a business, from the business side?
Remains the data privacy framework, what happens in the next 1.5 years, because what I see that it's an operational challenge if it changes every now and then. So it creates some kind of internal fatigue. When I approach my management with the same topic over and over again, I say, okay, we have again a Schrems situation. Then they say, oh, what again? So I think it weakens the cause of data protection to have this back and forth. I mean, we can't change it, so we need to probably slowly approach the final situation, and we have to reevaluate the situation. But still it creates internal fatigue to tackle this topic, and this necessitates even more fight for resources, and it gives a tough task on a DPO or any data privacy professional to advocate for data privacy if these things happen again and again and again. So what I would really appreciate is a greater long-term stability. Of course, the question is, what can we do if things change, but it doesn't only go for the US, it goes for all the countries. And this brings me to the second part. We have a growing regulatory framework worldwide for data protection. So we appreciate this global embrace of data protection principles, of course. I mean, as a privacy professional, I'm advocating for data protection, so it's good, but it demands resources. And again, greater global harmonization would be fantastic. So we've seen it in the past for other areas of law where we had big international treaties setting out some general standards, and harmonization mechanisms would be great. So that doesn't necessarily mean that we have to agree on the level of the GDPR, but if we have some kind of level that all could agree on, would make corporate life much easier. But that's my wish list, obviously.
Yes, thank you. And from your perspective, Ms. Nestor, where do you find the biggest gaps between the regulatory expectation and the operational realities?
I think it's this idea of what is considered enough. That companies are making investments and are trying to put protections in place, but the reality is that those expectations might be unclear. When I talk to other practitioners from a range of companies, many of those practitioners are just hoping that they can try to comply but stay under the radar. They don't want to raise their profile. They want to stay under the radar. They are transferring data around the world. Most countries, as we know, of course, are not adequate. The overwhelming majority of countries are not adequate. It's going to be very difficult for them to address the fact that the legal frameworks in all of those countries are going to be different than the EU, that they are going to have to look for legal advice for a range of countries. If you're trying to look, let's just say you're doing event planning, for example, and you have people coming around the world and you have events around the world, that can become a very dynamic, complex issue very quickly. And I think you would just be hoping that you can do your best. You might not have enough resources to give you independent assessments of legal frameworks. So I think there's some advice we could, talk to Alexander Filip later about in terms of specific elements that could help with transfer impact assessments, I think, to alleviate that. But I think that's the biggest gap, really, is people trying to comply in practice versus what that regulatory expectation is. And I always remember this classic privacy work, privacy on the books versus on the ground. This is from a long time ago, and I think it was looking at US practices at that point when there was less regulation, no state laws really at that point. And they did point out that the reality on the ground in terms of operational practices can be very different from what the regulatory expectations and what is on the law says.
Thank you. I would like to listen to your comments, Mr. Filip.
Yeah, so as I said before, I think the biggest challenge, of course, is for small and medium enterprises to live up to the to the really high standard which the European Court of Justice set in the Schrems II ruling, and to carry out these transfer impact assessments for any third countries to which they transfer personal data. So probably in practice, they will rely on the transfer impact assessments which have been already prepared in advance by the big tech firms, which usually offer these transfer impact assessments. So we know that the big ones provide their clients with their transfer impact assessments. So that will help to a certain degree, because they don't have, the small and medium enterprises don't have to do their work themselves. However, nobody will be able to give them legal certainty that the transfer impact assessment, which has been carried out by the big tech firm, really will convince also the regulator in a specific case. So that's the risk to be taken, and we've seen the press release by the Irish Data Protection Authority some weeks ago regarding one of a transfer of personal data carried out by a big company, which is among us here, to China, and in that case, as far as we know from the press release, because as far as I know, the decision has not been published yet, but the press release points out that the company has carried out a transfer impact assessment and has provided legal analysis by scholars regarding the laws in China and the data access by public authorities there. And the regulator, however, the Irish DPC, was of the opinion that it somehow does not exactly suit the specific situation. And so in any case, apparently a very elaborate transfer impact assessment had been carried out, but the regulator in the end, as a result, was not content that in that specific case, more or less, the impact assessment really suit the specific situation. So that's always what can happen. So even if you're a big law firm, a big tech firm with resources able to carry out these assessments, it's still the question is still whether that will convince the regulators. On the other side, the regulators also will have a lot of work to do, because they of course need to look at these assessments and just make up their mind whether that's the assessments are convincing. And if not, as in the case which I mentioned before, of course they need to find they need to argue, and they need to provide reasons for their assessment. So, but what the regulators will probably not do, they will not carry out themselves the transfer impact assessments, even for a specific situation, even for the case which they have on their desk. They will just say, it's up to you, the data exporter. It's accountability. You have to present what you have done, and if it doesn't convince me, then it's not enough. So it's more or less it's the onus is on the data exporter, not really on the authority. The authority, of course, will have to check everything, and if they will issue a ban or a decision stopping the transfer or suspending the transfer, they will have to provide arguments which are suitable, which are sufficient for the court, but they will not carry out themselves the assessment. Yeah.
Yes, thank you. And Ms. Nestor, Dr. Pasquariello, I would say that, can we point out the most unclear parts in the transfer impact assessment in practice? I mean, where are the difficulties to be found? You can start, Dr. Pasquariello.
Yeah, I'm wondering how to do a TIA if an adequacy decision has fallen. So that's my challenge we might face at one point. So, but I don't have a solution for that, to be very honest. We'll see when it happens, if it happens. And it might, I mean, at one point it must not only concern the US, it goes for all the countries where adequacy decisions are withdrawn. So let's see how we can argue that. And what I feel is one of the biggest difficulties is to find the expertise. And as we already mentioned, it's costly to find the expertise to actually do a proper impact assessment, to have the knowledge of the law in the respective countries. It's not only data privacy law, it's a combination of a large amount of securities laws and public law, civil law. So it's a lot of things that you have to take care of, and to get the expertise to actually do a proper assessment is tough. So every step or each step of the TIA is pretty clear. So what we have to do and what we are expected to do, but the knowledge to be able to do it is is really tough to get or expensive to get. And then it's not only one country. Even for the US, we have a multitude of jurisdictions within the US, so you have to assess it by state. That remains a challenge. So I think the expertise is probably, and the costliness of the expertise is the biggest thing.
Yeah, thank you. And Ms. Nestor, do you think are the same difficulties for you?
Well, I'll mention, I think, what the industry thinks, because I should say that the, quote, big, elaborate TIA Alexander Philip was talking about was TikTok, so I can't speak too much about the specifics of that. But I will note that the GDPR expert group, again, looking at what they said that perhaps things like templates or general country assessments or risk catalogs could be helpful for the TIA process. And I think separate from the TIAs, actually looking more broadly at other elements of this, that the EDPB could recognize that demonstrable accountability mechanisms beyond what they've already identified with certifications, for example, or compliance with ISO standards, things like that, demonstrable accountability from third-party oversight by some other organization could help a company demonstrate the efficacy of their organizational and technical measures. So going beyond that TIA question a little bit, just to say, I think we could think a little bit more openly about other ways that you demonstrate accountability and trying to achieve compliance with the law, in addition to looking at other best practices that have been alluded to in that set of recommendations so far.
Thank you very much, the three of you. I hope that the future brings more certainty and that the decision remains as it is. And now I would like to hand over to my colleague Isabel for the next panel discussion with the title Ready for AI, Rethinking Data Protection Governance.